Chuahuat v. CA. Facts. First case is a petition for review on certiorari of the decision of the CA, and the second is a petition for prohibition with PI directed against the notices of condemnation and demolition orders issued by the city engineer upon authority of the city mayor. In a civil case, the CFI sentenced the petitioners to pay 1 UI certain sums of money as well as to vacate the property and surrender to the same UI. The CA affirmed. Petitioners, except Oncoen, filed a petition for review on certiorari with the SC contending that the case is actually an unlawful detainer case, and therefore the CFI had no jurisdiction over it. The SC denied the petition. After the decision in the civil case became final and executory, the private respondents filed a motion to execute the same. The court granted this. Petitioner Chuahuat filed with the CFI a complaint for the annulment of judgment on the ground that the CFI has no jurisdiction over the civil case, which was one for ejectment and not for recovery of possession. Despite the case, the CFI ordered the execution of the judgment. The petitioners filed a petition for certiorari and prohibition with the CA to set aside the order of execution of judgment and to prohibit the respondents from executing the judgment. The CA denied the petition for lack of merit. The CA invoked finality of judgment and residential judicata. On appeal, petitioners contend that there is no residential judicata as there is no identity of causes of action. Issue 1. The present action is barred by residential judicata held, yes ratio. The records of the two cases will bear it out that the issue of lack of jurisdiction has been squarely ruled upon, not only by the trial court in civil case number 74,634 but also by the Court of Appeals and by the Supreme Court. Plaintiff appellant further contends that since the issue of jurisdiction in civil case number 74,634 was raised in their MR before the CA in CAG.R no 51337R, the CA did not, in its resolution denying said motion, pass on the same and on appeal by petition for review to the Supreme Court in L47603 and L48649, where the same issue among others was raised. The High Court in its minutes did not rule squarely on said issue. We find the same likewise untenable. Issues raised by the parties in their brief and passed upon sub silentio by the appellate court in a decision which has become final and executory are considered closed and can no longer be revived by the parties in a subsequent litigation without doing violence to the principle of residential judicata. What more, neither the Supreme Court nor the appellate court is duty-bound to discuss the pros and cons of appellant's argument. Tatel v. Mon. Of Virac. Facts, on the basis of the complaints received from the residents of Barrio Sta. Elena against the disturbance caused by the operation of the abaca baling machine inside petitioner's warehouse which emitted obnoxious odor and dust, a committee was appointed by the Municipal Council of Virac to investigate the matter. The committee noted that the warehouse was near residential houses and that the inflammable materials inside created danger to the lives and properties of the people within the neighborhood. Resolution 29 was passed by the Municipal Council declaring the warehouse as a public nuisance within the purview of Article 694 of the CC. The petitioner's MR was denied. Petitioner filed a petition for prohibition with preliminary injunction with the CFI enjoining them from enforcing Resolution 29 of the Council. The municipal officials contend that the warehouse was constructed in violation of Ordinance Number 134, S. 1952. Prohibiting the construction of warehouses near a block of houses either in the poblacion or barrios without maintaining the necessary distance of 200 meters from said block of houses to avoid loss of lives and properties by accidental fire. Petitioner contends that said ordinance is unconstitutional, contrary to the Due Process and Equal Protection Clause of the Constitution and null and void for not having been passed in accordance with law. The court ruled in favor of the municipal council and held that the ordinance was a legitimate and valid exercise of police power by the municipal council. Issue 1. The enactment was pursuant to a legitimate exercise of police power. Held yes. Ratio, Ordinance Number 13, Series of 1952, was passed by the Municipal Council of Viereck in the exercise of its police power. It is a settled principle of law that municipal corporations are agencies of the state for the promotion and maintenance of local self-government and as such are endowed with the police powers in order to effectively accomplish and carry out the declared objects of their creation. Its authority emanates from the General Welfare Clause under the Administrative Code. For an ordinance to be valid, it must not only be within the corporate powers of the municipality to enact but must also be passed according to the procedure prescribed by law, and must be in consonance with certain well-established and basic principles of a substantive nature. These principles require that a municipal ordinance must not contravene the Constitution or any statute, must not be unfair or oppressive, must not be partial or discriminatory, must not prohibit but may regulate trade, must be general and consistent with public policy, and must not be unreasonable. Ordinance Number 13, S. 1952, meets these criteria. In spite of its fractured syntax, basically, what is regulated by the ordinance is the construction of warehouses wherein inflammable materials are stored, where such warehouses are located at a distance of 200 meters from a block of houses, and not the construction per se of a warehouse. The purpose is to avoid the loss of life and property in case of fire, which is one of the primordial obligation of the government. Experience, however, will show that this is not uncommon in lawmaking bodies in small towns where local authorities, and in particular the persons charged with the drafting and preparation of municipal resolutions and ordinances, lack sufficient education and training and are not well grounded even on the basic and fundamental elements of the English language commonly used throughout the country in such matters. The ambiguity therefore is more apparent than real and springs from simple error in grammar, but otherwise the meaning and intent is clear, that what is prohibited is the construction or maintenance of warehouses for the storage of inflammable articles at a distance within 200 meters from a block of houses either in the poblacion or in the barrios. And the purpose of the ordinance is to avoid loss of life and property in case of accidental fire, which is one of the primordial and basic obligation of any government. As to the contention that warehouses similarly situated as that of the petitioner were not prosecuted, the mere fact that the municipal authorities have not proceeded against other warehouses in the municipality allegedly violating Ordinance 13 is no reason to claim that the ordinance is discriminatory. A distinction must be made between the law itself and the manner in which said law is implemented by the agencies in charge with its administration/enforcement. There is no valid reason for the petitioner to complain. In the absence of proof that the other bodegas mentioned by him are operating in violation of the ordinance and that the complaints have been lodged against the bodegas concerned without the municipal authorities doing anything about it, the objections interposed by the petitioner to the validity of the ordinance have not been substantiated. Its purpose is well within the objectives of sound government. No undue restraint is placed upon the petitioner or for anybody to engage in trade, but merely a prohibition from storing inflammable products in the warehouse because of the danger of fire to the lives and properties of the people residing in the vicinity. As far as public policy is concerned, there can be no better policy than what has been conceived by the municipal government.